All right. We're in Chapter 6, Court System and Alternative Dispute Resolution, and Part 1 of this lecture that's posted. We went over the court system. I'm just going to briefly review like I would do in a seated class, and then move on to, it'll take like 15 minutes for this whole lecture, unless you have questions, and then move on to the final chapter portion of the chapter, Alternative Dispute Resolution. We started the chapter with, there's 2 basic requirements to qualify to bring a lawsuit. Anybody remember what they were? Standing to sue. You have to have standing to sue, and it has to be a justiciable controversy. You have to have been the one injured or represent a minor or incompetent that was injured. You have to have a sufficient stake in the outcome to have standing to sue. And a justiciable controversy is one that is real, not hypothetical. Okay. All right. Then we went through that list of jurisdiction. It's really important that you do learn the different types of jurisdiction, because you will hear them throughout your paralegal legal life, and you will need to know and identify whether or not you have jurisdiction, and you will also know which court to go file your complaint in when your attorney says, take this to the courthouse. But it'll usually say in the court on the complaint, but you want to make sure you get the right court. The list is there. If anybody has any questions about the different types of jurisdiction, I'll take those, but I don't need to go over those, I don't think. It is on the exam, so you will need to know them. But if you have any questions about the different types. I did notice, maybe this was in the other section of it, in the questions, if I've not graded them yet here, in personam, it's not personam jurisdiction, it has to have the in before the personam. It's 2 words, in personam jurisdiction, over the person. And you get jurisdiction over the plaintiff when they file the lawsuit. They submit their jurisdiction to the court and say, you can have jurisdiction over me to rule on my case I just filed. And then when the defendant is served, they have in personam jurisdiction over the defendant. Subject matter jurisdiction is which court it can be heard in. Which court it can be heard in. You have to file family court matters in family. Divorces would go in family court. Probate of estates, you have to file them in probate court. Things like that. Subject matter jurisdiction. Jurisdiction over the property means, that's called in rem, and that means the real estate. And you can only bring a lawsuit regarding real estate, real property, where the property is located. So there's other types of jurisdiction, and if you have any questions on those. All right. And cyberspace was the most recent one because of technology and how we purchase daily from Amazon. Venue is different from jurisdiction. That's the actual geographical location, the physical location of where the case is heard. And you can ask for a change of venue if you're not going to get a fair trial, if it's some heinous crime, if they think they're not going to get a fair trial. But that's up to the court to say whether or not they will do a change of venue. And then we went over the big handout, and you've got that in there with the dual court system. That means we have a federal court system and a state court system, and all the states have can have different state court systems. Right now there's an election going on in November if you're a registered voter in North Carolina, and there are people running for justices in North Carolina, so get to know them. Get to know them before you vote. Questions? Okay. And we learned about the federal court system, that the North Carolina is in the Fourth Circuit of the federal court. And there are other states in that Fourth Circuit. And the structure of the courts, trial court level, Court of Appeals, and then the Supreme Court. We learned that not all states have the name Supreme Court for the highest court. Some states have two court systems. They have a criminal court system and a state court system and a civil court system in their state. So if it's criminal trial, you go there. Civil trial, you go here, and the two don't meet. Texas is one of them. Okay, let's see how far I got. I think we're up to court page 160, 159, 158. Alternative dispute resolution. And there's three basic kinds. Sorry, my husband was calling from the emergency room. He's in critical care right now, so there you go. But at least he can use the phone, so I guess he's going to be all right. ADR, it's less expensive, it's non-adversarial, and it's less time-consuming than litigation. And you don't have to pay attorneys to draw out a trial. What they do is before you go into heavy litigation, we get together and try to settle it. And the three basic types are negotiation, mediation, and arbitration. Negotiation, mediation, and arbitration. They're relatively same, but they do have their unique characteristics. Negotiation is informal. The parties and attorneys meet generally in two separate rooms, and they go back and forth. And it can be before the trial to decide whether or not we can settle it without going into litigation, or at some point during the trial, you can stop and say, we want to negotiate, and we'll take a pause from the litigation and we'll go and try to hammer it out. So once the parties agree, the attorney will come in, ask their client, this is what they're offering, what do you think? It's like buying a house, and you go back and forth until you come to an agreement. They negotiate. It's written up into something that's called a settlement agreement, and they have a example of one on page 160 in your book. Settlement agreement, they both agree, and it becomes a contract, and it's notarized, and it's presented to the court. And then the court will enter their order honoring what the parties have settled upon. And the thing with that, now that it's a contract, if after they leave the courthouse, one party goes, I don't really want to do that, well, then the other party can sue on that contract, and they have to abide by it. Okay? So the second type is negotiation. Mediation. Sorry. It's also informal, and it's non-adversarial. And what happens with that is they have a neutral third party come in. In negotiation, it's just the two attorneys and their clients, or if one's not represented by an attorney, it's the client, it's the plaintiff or the defendant, and the attorney on the other side. In mediation, you have a third party that steps in called a mediator. And a mediator does not make a decision. They make a recommendation. They can just recommend. So the parties pick from a list of approved mediators. And in North Carolina, we have one. Let me go over here and share this with you. I'm going to go share application screen 1, share, hide. over here. I post a lot, don't I? Here we go. We're talking mediation. Let me see. I put it somewhere. Story of my life. Oh, for Pete's sakes. All right, so maybe I didn't. Oh, here it is. I did. All right. If you have a child custody action, it's mandatory that you have to have mediation to try to resolve the problems. And if you're getting a divorce, it's really hard to mediate, especially if it's a contentious divorce because they're not happy with each other. But anyways, it's no longer Myra Appeal. I haven't updated it. This is, it's Lori Wainwright, I believe. And you have to have this notice. And anytime you file a family child custody action, you will get this notice from the court if you're the plaintiff, and then the defendant will also be served with this notice. And they say if you fail to attend a scheduled mediation, you may be held in contempt of court unless you've been excused. So we have local rules that require mediation. Now the mediator recommends, and you don't have to accept it, and you can still go on and go to litigation if you don't like the mediator's decision. Okay. Arbitration is the last one on the ADR list. And it's the most formal method of ADR. The arbitrator is acting as a private judge. He's not a judge. So since he's not a judge, he cannot make a decision. He can only make an award. It's not an order. It can't be termed an order because that's only for judges. Arbitration can be binding or non-binding, which means you have to adhere to it. If it's binding, non-binding, you can go, don't want that, I'm going to go to trial. A lot of you have, well, everybody has cell phones. If you read your cell phone literature that comes with your cell phone, nobody does, it says that where you will have binding arbitration if you have any disputes with your telephone provider. So nobody reads that, but you'll see that if you do take a peek at it. And they do that, it's binding because they're the big guys. All right, on page 166, they have examples in the book of all of these, but you can all read. On page 166, there's collaborative law. That's another form. The main three forms are what I said: negotiation, mediation, and arbitration. But then there's other ones that have been coming up over the years to try to remain cordial to each other and try to get along as we sue you. So collaborative law, and we have this in family law. If you have my family law course, that you can have a collaborative law divorce. So both, it's just like a negotiation, but it's called collaborative law. And they have the attorneys and the clients, and they try to work it out, collaborate, and do it peacefully to share, to reduce animosity and be nice to each other. And then we have the court-referred ADR, and that's the child custody one. So we do have that. They said on page 166, the Uniform Collaborative Law Act, written by the Uniform Law Commission, has been adopted in about a dozen states, and North Carolina is one of those states. There's also something called a summary jury trial. That's in the margin on page 167. And what they do with that, a summary judgment trial, is a trial is held, and then the verdict acts as a suggestion. And if they don't like what the court orders in the summary jury trial, then they can go have a full-blown trial. But let's try to be nice. Let's try to get it done easily, and then the court will decide. And if you don't like it, you can have a real trial with witnesses and evidence. Okay. I'm going to stop recording because that is basically the entire lecture in under 16